Okay, I'm going to go over the practice problems from class 2. The first thing that we're going to do is pull up the case. I'm just going to copy and paste the citation right into the search bar. But I can see right here I have some filters set. So I'm going to just say all states, all federal, save. I have my citation, it's going to search everywhere. We'll press search. Okay, the instructions tell us that the language that we're looking for is under Roman numeral 3. So over here on the left, we can open this up and we see the different parts of the document. I'm going to click on number 3, merits. And it said the language that we're looking for is this right here. A party claiming title by adverse possession must establish hostile, actual, open, exclusive, and continuous possession. So to trace this back, the first thing we're going to do is this is citing this C.H. Moore case. So I'm going to trace this precedent back by clicking here. Then it opens up this case and it is going to take me pretty close to where I would need to be for the adverse possession language that we are looking for. So I'm looking and I'm not really seeing it. So if I just do a little Control F and I do claiming, we can see that there's a head note there. But we don't want to be in the head note. We want to be in the opinion, and then here we are right here. A party claiming adverse possession. That's the exact language that we're looking for. Now the first question asks, how quickly do you get to an Iowa Supreme Court case? Well, we can see that this C.H. Moore Trust Estate case is an Iowa Supreme Court case. So there we have it. It's the very first case that we got to. Then it asks us to trace the precedent back through 3 additional cases. So we're here. If we click on Marksbury v. State, that will take us to another one. And then we can see here that we're talking about the same language down here about the claiming title by adverse possession. Here's the language that we're looking for. We can go back, keep going back. Council Bluffs. And then we get to all of these cases here. So 1, 2, 3, 4, 5, 6 cases. In Westlaw, we're going to do the same thing. I'm going to check first, make sure that all my filters are off. Then I can put our site right there. It's going to take us to the case. So in the case, we're going to be looking for, again, under that Roman numeral 3. Over here, they actually have a slider instead of expanding it. So we can drag our slider down. We see number 1, number 2, number 3. The board contends that established ownership. Okay, so then we have our quote, and then we have our case. And it's just the same process from here. We're going to be finding that same language each time. And then we're going to click on the case to trace it back. Okay, I'm going to go over the practice problems from class 2. The first thing that we're going to do is pull up the case. I'm just going to copy and paste the citation right into the search bar. But I can see right here I have some filters set. So I'm going to just say all states, all federal, save. I have my citation, it's going to search everywhere. We'll press search. Okay, the instructions tell us that the language that we're looking for is under Roman numeral 3. So over here on the left, we can open this up and we see the different parts of the document. I'm going to click on number 3, merits. And it said the language that we're looking for is this right here. A party claiming title by adverse possession must establish hostile, actual, open, exclusive, and continuous possession. So to trace this back, the first thing we're going to do is this is citing this C.H. Moore case. So I'm going to trace this precedent back by clicking here. Then it opens up this case, and it is going to take me pretty close to where I would need to be for the adverse possession language that we are looking for. So I'm looking and I'm not really seeing it. So if I just do a little Control F and I do claiming, we can see that there's a head note there. But we don't want to be in the head note. We want to be in the opinion, and then here we are right here. A party claiming adverse possession. That's the exact language that we're looking for. Now the first question asks, how quickly do you get to an Iowa Supreme Court case? Well, we can see that the C.H. Moore Trust Estate case is an Iowa Supreme Court case. So there we have it. It's the very first case that we got to. Then it asks us to trace the precedent back through 3 additional cases. So we're here. If we click on Marksbury v. State, that will take us to another one. And then we can see here that we're talking about the same language down here about the claiming title by adverse possession. Here's the language that we're looking for. We can go back, keep going back. Council Bluffs. And then we get to all of these cases here. So 1, 2, 3, 4, 5, 6 cases. Go into the first case. And we can see the synopsis right here. But it's useful here to use something called the head notes in West. So in the head notes, it's going to be giving you the main topics that are in this case. And so here the very first one is, a minor can in most cases disaffirm a contract during his minority. So if I click on that head note, it's going to zip me down into the opinion as to where it talks about this issue. And it says, a minor can in most cases disaffirm a contract during his minority. Now, this case doesn't actually say under what circumstances though, so we're probably going to want to go back to our list of cases and try to find out under what circumstances. So we'll take a look at the next case down. So if we're looking at our head notes, we can scroll down. A parent has an illegal right. Any settlement of a minor's claim, parent and child. A minor can disaffirm a contract before reaching the age of majority. Click on this. I'm just looking through that to see if I can find the rule of under what circumstances. That doesn't seem to address it either. So what I would do is keep going through all of these questions, all these cases, till I find one that actually addresses the issue of under what circumstances. For Lexis, I'm going to select cases up there, so I'm only looking at cases. And then I'm going to look through here for the answers. Now, Villalobos in this one is at the very top. So let's click on that one. Now we know this one doesn't address it, but we also want to see how it looks inside the case, how Lexis and Westlaw differ from each other. So this one, you can see that there's also head notes. If I'm trying to move this down, I could go down to the head notes, and then there's also head notes there, and we can just click on this, and it'll again jump us down to where we want to be in the case. Okay, now we're going to try a Boolean search phrase. So I'm going to say minor and disaffirm exclamation point, so we can capture all of the different types of that word, however it might appear. And we're going to say within the same sentence as a contract. Okay, so if we're going to do the search in Lexis, let's try this one, minor and disaffirm and contract. And we can check and see. Yep, we still have Illinois highlighted. So here we go. All right, so it takes you initially right to statutes and legislation. We're not interested in that, so what we want to do is go to cases. You can see our number of cases has drastically gone down. So we can look through here, and again, it's going to be a list of the cases, and instead of clicking off this page, maybe you want to just look through the excerpts. Here is the overview, and we can look and see that this is something about a car, and so this one might be helpful. So if we go down to our head notes, we can see all contracts with infants except for necessaries as voidable in the instance of the infant. So if I click on my head note, that's going to take me down here. All contracts with infants except for necessaries as voidable. So that's giving us a lot more information actually, that these are voidable unless it's a necessary. And then if I keep scrolling down, the court in a memorandum opinion held that minors upon restoration of an automobile to the seller, although it has been used and deteriorated in value, are entitled to rescind the contract of sale and recover back that part of the purchase price which has been paid. So this looks like our case that's going to answer all of our questions here, and that was just me looking around in the case trying to find what might be applicable. If we're back in Westlaw though, if we want to look and try to see if we can use a digest, let's click over here on key numbers and see if there's anything that might be interesting to us about these topics. So requisites, validity, operation, and effective contracts. So if we're going to open those up, let's see. This is our keynote 211. And we're in contracts, so we can see up here, here's our little breakdown of where we are, our little hierarchy. So we're in the key numbers, we're in number 211. We're talking about contracts, so the big topic is infants, contracts, requisites, validity, operation of contracts. So then we can see through here, there are a lot of the similar cases that we saw. But maybe we want to go up to here, the next level up, to see a more general topic, to see if there might be a smaller key number, a more narrow key number that's going to answer our question. So for here, requisites, validity, operation, and effect of contracts, we can see here that here we are. So we've got a lot of interesting cases here popping up, and you can see that we're still in Illinois. We're still in Illinois, which is where we want. So that's going to be another way that we could get at a lot of helpful information about the topic that we're looking for. So these are all going to be topics that fall under the 10.1054 requisites, validity, and effective contracts. So if I keep scrolling down though, we have ratification and affirmance. We have avoidance and disaffirmance, which is what we were looking at in the beginning. We can say time of ratification or avoidance. We aren't talking about time in ours, so that one's not interesting to us. So we can see, we can probably scroll into the next page, but we can see that this second one, this avoidance and disaffirmance, that does where we want to be. So we can go through and read through these little previews and try to find out if there's one that's going to give us the answer that we want about when can a child disaffirm a contract. Okay, so now we are going to be talking about the question number at the bottom about the non-compete contract. It starts like number 6. So looking through the fact pattern, we can see that our jurisdiction is Arizona. So I'm going to want to make sure first and go and change my jurisdiction to Arizona and unclick Illinois. And then that's going to be helpful to us when we're doing our search. But we're looking first in the ALR. So just as a reminder, the ALR is under secondary sources, American Law Reports. And we can look through here. We're talking about contracts, but that might be too general of a term that's going to be in here. So that's okay. We can search in here and we can look for our, just say We search in our ALRs for non-compete. So I did not do a Boolean search. I just did straight up natural language non-compete, compete, and it's giving us a whole big list of ALR articles. I can do the same thing in Lexis. I'm going to go in here, change my jurisdiction to Arizona, turn off Illinois, and we are going to be going back over here to our secondary sources. Now, in this case, jurisdiction doesn't really matter because we're just looking at ALR articles, and it was the same on Westlaw, but I always check the jurisdiction. I just always check it. Just check it, because then you can know you're looking in the right spot. Because if you go down a rabbit hole and you start finding things in the ALR, like cases you'd like to look at, well then, you're in the wrong jurisdiction, so that's not helpful. So I'm going to click here on secondary materials. ALR is right there at the top. We can type in here and just say non-compete. I'm going to search non-compete. And so then it's giving us the same ALR articles back again. Now the issue though is what she wants to know is whether she can dispute the time and place requirements of the non-compete. So we can talk about looking through here, which one's going to be most on point for what our issue is. So we can say enforceability of restrictive covenant ancillary to employment contract as affected by territorial extent of restriction. So that's great because we are looking for distance, so territorial extent, that's going to be distance. We can click in here, and by the way, this looks the same in Westlaw, so if you click in there, you're going to get the same document. It might be a different font, might be a little bit different format, but it's going to give you the same ALR article. So if we're up here at the very top, we want to go down to the bottom, and we can see throughout this ALR there is a bunch of different cases. As we move through it, it's going to give us a little bit of general explanation, and then as we go down, it's going to be telling us some other articles that might apply to our situation. But I'm still scrolling, and I can see here that there's cases for some different jurisdictions. So I could keep scrolling down, or I could just do my Control F and say Arizona. And then, so we can start seeing that there's a couple cases. So we can go down here. Under Arizona law, the restrictive covenant not to compete is reasonable. So you can get a little bit of good information from this ALR that way. We can also see here that this is part 1 of 2 of this ALR article. So if I want to look at part 2, I can click over here. And here we go. So we're having a little bit of more information in here, and possibly I'll just do my Control F again for Arizona, and we can see Arizona appears a few different places in this article. And so looking through those cases would be a good place to get started. So reading through those cases to see if you can find out whether or not the range, like the zone, is applicable. Now, if I want to go back, though, because we are not just talking about the area the non-compete is, we're also talking about the time. So how long can it be? Here we talk about the duration of restriction, and that would be just the same thing. We're going through there, taking a look to see if we can find any information about Arizona's rules as far as how long the duration of the contract can be. And again, this one also has part 2, so just making sure you're checking that as well. Okay, now we're going to look at Class 3 assignments. The first question is mistake of law, a defense to a crime, and you're going to look up this in these following legal encyclopedias. So American jurisprudence. So again, I'm going to look in secondary sources. Look in secondary sources. we're going to see jurisprudence and encyclopedias. Click on that. And then we have our American jurisprudence. So you can see up here that these are already being filtered somewhat. So what we're trying to look for is mistake of law. So if I type in here, mistake of law and crime, now we're searching just the jurisprudence and legal encyclopedias. So we can see here there is a whole bunch of different types of things that you could look in, but remember we just wanted to look in American jurisprudence. So if you are trying to really limit it more than that, we would want to be able to eliminate out all of these other sources. So if I come over here to the side, I can click on publication name, and then right here, American jurisprudence is at the top. Now it's just going to give us only American jurisprudence articles that are in here. So if we can say, look through here, mistake of law generally, then you can see down here, we can go through that no, mistake of law is not a defense to a crime. Now here, remember we chose AmJur, but we want to now just look in New York. So we can scroll down and choose the title, just the New York jurisprudence. And we can see it right here, New York jurisprudence. Okay, mistake of law as a defense, and then you can find that article right there.